First off, I want to thank you for so hospitably caring for our governors and your prison system. It speaks for itself. And we were glad to finally get a governor out of office without an indictment pending. The second, I'll tell you, it seemed as if half the members of the Senate Judiciary Committee had taken constitutional law from Professor Conkle, and now having seen his expertise up close twice, I do wish I'd been able to take your class up at the school I attended, the little school up in South Bend. Now to the bill. The key aspect of the Religious Freedom Restoration Act is to provide a broad fence around that core right of the free exercise of religion. And one key point about this act is that while religion usually has a communal aspect, it is also very strongly individual. So with this act, it doesn't try to legislate every little exception that this or that religion might have to a law. And really, in fact, in the process of deciding by majority vote which religion should get exceptions and which shouldn't, that itself may set a difficult or dangerous precedent. So to that extent, this bill is a common sense live and let live protection. And again, this is one of those rights not given by government, but inherent in a free people. We see these rights recognized in the Declaration of Independence and in our federal and state constitutions. Now, most of what we do as legislators does not touch on core fundamental rights. I mean, we're setting taxes and fees, we're building roads, we're trying to figure out where to appropriate money, or even what to name a particular building. But we don't normally get into these deep issues of religious conscience. And so I would submit to you that when we do wade into these issues that touch on fundamental rights, we give those rights a wide berth. Protect the fundamental rights broadly, only curtailing them when absolutely necessary. This is precisely what the bill before you today does. And it's, of course, in America, unlike these philosophers of Europe, which advocated for mere tolerance for religious practice and for those who had minority religious beliefs, the founders of our country actually specifically considered and rejected this idea that we should merely tolerate free exercise of religion as if it were a right granted by the government and not inherent in the people. Now, as noted by the law professors in their very erudite letter on pages 4 and 5 with Professor Conkle and other professors across the country, including professors from Valparaiso and Notre Dame, this bill sends a message to those within the government then that, when in doubt, err on the side of religion and religious freedom. Now, one of the reasons I was asked to testify today was my particular experience in a case litigating against the state of Indiana. We went up to the Indiana Supreme Court in that case. I was representing a group called the Fishers Adolescent Catholic Enrichment Society. That's a group, of course, in the northern suburbs of Indianapolis. It was a 10-family, all-volunteer homeschooling group. Went through roughly 6 years of litigation with the Indiana Civil Rights Commission. The commission sued this group at the behest of a disgruntled mother after a religious and social event was not run the way that that mother wanted. Now, the entire power of the sovereign state of Indiana was arrayed against this small volunteer group, and they charged them with the strong crimes of discrimination and retaliation. Now, the charges were bogus, and we were able to get the initial discrimination charge dismissed, but only after several years of litigation. The volunteer moms running the group were subject to invasive discovery. They spent hours under deposition. They had to go through very invasive document requests, searches of their email and interrogatory requests, along with a trial. And now, however, there was even no merit to the discrimination charge. The alleged retaliation charge was upheld. They had a $5,000 fine entered against them and an injunction. Now, of course, this is a group that never had more than $1,500 in the bank, and again, was a very small volunteer group. And now we took it up to the Indiana Court of Appeals, and they upheld, unfortunately, the lion's share of the decision by the commission. It was only the Indiana Supreme Court that put an end to this business after forcing hundreds of thousands of dollars in attorney's fees to be expended, and that was just on our side. The state of Indiana spent many hundreds of thousands of dollars of taxpayer money tormenting this small religious group on a frivolous discrimination charge. Now, the families disbanded the volunteer group, exhausted from fighting the entire power of the state. Now, early on, we raised our religious liberty concerns. We tried to get it heard by the commission. We tried to get it heard in the local district court in Hamilton County, but they refused to act to stop the proceedings. Had there been an Indiana Religious Freedom Restoration Act, we might have been able to get this case thrown out. And in fact, we might have even been brought before the commission at all, because its staff would have thought twice before wading into the affairs of a small religious group if they had had to contend with a Religious Freedom Restoration Act. It's heartbreaking for me to think that had an Indiana Religious Freedom Restoration Act been in place, those families would have been saved years of torment, and the Fishers Adolescent Catholic Enrichment Society would be here today, providing wholesome religious enrichment opportunities to children in the northern suburbs of Indianapolis. So now, ladies and gentlemen, while we got a positive decision from the Indiana Supreme Court in our specific case, there's no law in the books protecting the next small religious group from being dragged before the Indiana Civil Rights Commission or some other body. Hoosier families and organizations need this bill to become law. And in fact, just over 1 week ago, an Indiana school, that same University of Notre Dame, was given relief by the U.S. Supreme Court under the federal RFRA from federal government action. And that was under that Hobby Lobby precedent, the reason for this bill today. The problem is Notre Dame and other entities like it don't have the same religious liberty rights against a local, county, or state action. Only federal action do they have protection. Now, I do want to address some objections to the bill very quickly. First off, it's been noted in 1993, the ACLU strongly supported the Federal Religious Freedom Restoration Act. They issued press releases lauding the act and demanding that it be put in place right away. It was religious minorities that were at issue then. It's Jehovah's Witnesses. It was Native Americans smoking peyote. Those groups vociferously, the groups the ACLU vociferously wanted strong protection. But now today, my colleagues at the ACLU are against this act. Now, why is that? What's really changed in the last 20 years? Have we become so enlightened that in a short 2 decades, we no longer need the centuries-old tradition of the freedom of religion? Or is it that this fundamental right may now protect evangelical Christians, mainline Protestants, or Roman Catholics? Why is it all of a sudden that this fundamental right is not so important, not so worthy of protection? I would suggest to you that this sort of thinking is the worst sort of ends justifies the means thinking. Also told there are some of the business community who are opposed to this bill. Now, I am a pro-business legislator myself, but even apart from that, there's nothing anti-business in this bill at all. It's got no effect on business, and if you look at our example in Illinois, it's had a positive effect. In Illinois, we are Illinoised, as you all remind us regularly, and we're trying to improve our business climate as best we can. But on this particular issue, our disgraced former governor, Rod Blagojevich, had issued a rule that every pharmacy in the state had to give out pills that may cause early abortions. We had a family pharmacy in Illinois that took the rule to court, and because of our state's Religious Freedom Restoration Act, along with our state's Healthcare Right of Conscience Act, they won at the trial court and were able to continue operating and continue to have their family business in the state of Illinois and not have to move to a state where they would not have these sorts of anti-religion actions taken against them and burdens placed on them. And it had been alluded to earlier. Folks, there are many reasons why Illinois is considered a business-unfriendly state, but our Religious Freedom Restoration Act is not one of them. I would have heard about it otherwise. So again, I just very strongly urge you to cut through the hype and view these facts, that the Indiana Religious Freedom Restoration Act is a sound, considered, and appropriate protection for the people of Indiana and their religious liberty rights. Thank you.
Any questions from the committee? Representative Washington?
Yeah, so if I understand you, would you agree that it's practically easier to litigate in the presence of statutory provisions than under just pure constitutional language?
Absolutely, and really you put a court in a tougher position trying to interpret a constitutional provision, particularly one that was passed in 1851. It is appropriate for us as legislators to say to courts, hey, we want to put a broad fence around those rights and make sure folks are protected.
Thank you. Thank you, sir. Appreciate it.
Thank you.
Mike Fichter, and then